religions, both both provocative and real, or should I say provocative and established, have made the argument that abortion is religiously required. And the Satanic Temple, in fact, which is not actually a group of people who worship Satan. It's a group of people who believe in separation of church and state and try to push the point. They've actually brought challenges to abortion regulations saying our religious belief believes this about, and they explain their religion and they explain their religious rituals and they try to argue that this law is in violation of it, and they've been rejected. Now, maybe that's because they're known to be provocateurs. I also will point out that there are the Jewish faith, right? In the Jewish faith, life does not begin at fertilization. It's rather later. And there are a lot of biblical teachings that make it very clear that before birth, the pregnancy is just considered part of the woman and is treated as such. And there are also teachings that to the extent it might endanger the woman's life or well-being, the woman's life takes precedent. So I definitely can imagine a Jewish woman bringing a challenge to abortion law, saying that it violates her religious observances. Unfortunately, right, even assuming a court will say, okay, we have to apply some kind of heightened scrutiny to it, right? The same state that's going to ban abortion is going to be a state that thinks that it's murder and that protecting life is a compelling government interest. I could be
wrong. What is the basis? You have to come up with a basis for deciding it's murder. I mean, I understand what you're saying, Professor Segall, but what I'm saying is, of course you do. Because, look, you have to at least put words on a piece of paper.
And
that justifies your belief. And if you have the entire medical establishment, I can sit here and say, if I ovulate, that's a loss of life. I can sit here and say, if I cut my finger, some of the cells die and drip out, the blood cells are living cells.
I have before me Louisiana's law that just passed that has banned, that has made abortion murder and has said that life begins at contraception. Acknowledging the sanctity of innocent life, created in the image of God, which should be equally protected from fertilization to natural death, the legislature hereby declares that the purpose of the act is to fully recognize the human personhood of an unborn child at all stages of development prior to birth from the moment of fertilization. That is the compelling government interest, to honor the sanctity of innocent human life. Now, I will point out that Louisiana blundered because they put in their statute created in the image of God. So I think this
Won't matter.
I think
cynical Professor Segall.
Alone, but this is evidence that it's just a religious belief. I mean, they say right here, this is a religious belief. But unfortunately, I think what's going to happen is they're going to be like, this is protecting innocent.
So, Brown, I know. So I wrote a piece 2 weeks ago saying the title of it was "The Erasing of the Establishment Clause by the Roberts Court." That was the name of the piece. Caroline, of course, is exactly right. The Roberts Court has erased the Establishment Clause from the Constitution. I don't mean to beat a dead horse here, but judges who feel like they can take a constitutional provision and ignore it, wipe it out, delete it, aren't acting like judges. And on the issue of any kind of argument that I have a religious right to terminate, I meaning a woman, has a religious right to terminate a fetus, you're not asking the right questions. I'm sorry. You're just not. The right question is, what would Sean Hannity do?
I understand that that's your perspective, Professor Segall, but I'm not just in a reactive world reacting to what we're in. I'm also in a prescriptive world where I'm saying what should we be arguing for as leftists.
I'm making a bigger point. It's a point that Mark Tushnet has made throughout the years. He just retired as a Harvard law professor.
I know. I had him for admin law.
Okay. It's a point that Larry Kramer has made, that people who are much more famous than I am have made for a very long time. Listen, if the three of us were on the Supreme Court, this Supreme Court, and we had life tenure and couldn't get fired and could do anything we wanted as long as the people accepted our opinions, that's the constraint. We have no army, we have no money. So we have to only issue decisions that the president will enforce and the American people will accept. But if the three of us are on the Supreme Court, you know what the constitutional law would look like? It would look like Bernie Sanders' programs, because all three of us would agree with 99% of what Bernie Sanders says. And we would do that because we could. And there is not enough character in a human being to take a job like this. So I want to get to this point on abortion specifically. I didn't expect anything different about the result of this. I mean, I thought it might take 3 years. I think Caroline thought the same thing. But this is happening faster than I thought. But there was never a doubt that a court of this personnel would reverse Roe and Casey. There was just never Roberts would have gotten around to it 3 or 4 years from now. So what I'm trying to fight against, you're not letting me, is this idea that we have to talk about doctrines and establishment clauses and principles and cases to prescribe to others what they should do. Yes, we teach our students to talk the talk of con law. We do. I do that all the time. They have to pass the bar. They have to argue in front of judges. But to really make change, it takes other tools. And that's a serious point. I'm being really serious about that. It takes a Federalist Society backed by Leonard Leo. It takes, in the case of one person, one vote, it took the NAACP decades to come up with the right argument. They started off with and it took them decades to get the right people on the court. Brown took decades to get the right people on the court. And even then, we only got it because the Chief Justice died. And we might not have had it without that. So when you yell at me about ridiculing legal arguments, it's not true in traffic court, it's not true in the Court of Appeals, and it's not true in state courts. But at the Supreme Court of the United States, you don't argue. Those arguments don't matter. They never have.
So, Professor, I completely agree with you, and I completely agree with you. And we did a whole episode where we talked about this, and we agree. I did a 17-minute radar on the Hill 2 days ago, which I argue that the Supreme Court should not have the power of judicial review, and I completely agree. However, I think it's interesting to understand exactly how far this opinion departs from legal precedent, because I had 3 lawyers here, and I think it's important for people to understand that this was an act of judicial activism greater than, or at least equal to, the claims that the right has been making for the last 50 years as part of the effort you described by the Federalist Society to characterize the left as judicial activism. I think it's useful to take at least the 30 to 40 minutes of this conversation to explain exactly what is happening so that people can lobby a response. I tweeted out earlier today for people to give me recommendations for who to talk to about how women in other countries have advocated for abortion rights and much more conservative context by using the power of protest and labor withholding. And those are episodes that will come out in the future with activists and others who can really speak to those kinds of efforts.
I'd go for sex withholding.
What is that? The Lysistrata? What is the Greek play where that happens? But that's beside the point. While I have you lot here who are experts in this, I want to ask you what you make of the response that a lot of people have had, which is to say we have to codify Roe, that should be the next step.
They're going to strike that down too.
Right, but
they're going to strike that down.
But some people have argued that even if it were to be stricken down, that it's worth doing for political reasons. And that there's a different kind of political cost to Republicans having a full-on battle about the law than just an explicit law, as opposed to something that was created by the court. Glenn Greenwald had a piece on his Substack a few days ago where he argued that you can be mad at the Supreme Court because you don't like the outcome, but you can't argue that this isn't what the Supreme Court does. The Supreme Court is this anti-majoritarian thing that is about protecting elite interests. It is what it is. It's going to do what it does. And that it's only judicial activism if the Supreme Court is ignoring a law. And there's a tension between, the Constitution and the law. And at that point, they do go on a frolicking detour and basically express their own individual well-being. But absent a law, it's difficult to say that this isn't just one act of judicial activism canceling out another act of judicial activism. Does that resonate? I see you kind of shaking your head, Professor
I have a lot of different thoughts going through my head right now. Just one earlier response to Eric is, although many of his comments may accurately describe the Supreme Court, there are also lower courts, and I think they don't act quite as, some of them may be pretty freewheeling.
I agree. I agree.
Feel bound by the precedent and the giving of reasons. And so I think and honestly, most things don't go all the way up to the Supreme Court.
I agree.
So even assuming Eric is right, I think it really is important to discuss sort of the legal doctrine and the reasoning. So one question about judicial activism, I just want to point out that there was no reason for the court to take this case at all. It was really quite straightforward. The court has said since Roe that bans before viability are unconstitutional. Every subsequent case, it's discussed this, has said the same thing. Abortions before viability are unconstitutional. The Mississippi's ban is a ban before viability because it's at 15 weeks, and viability, which is the point at which a fetus might survive outside the womb, is not until 24 weeks. Both the district court and the Court of Appeals struck down the law. Usually it picks up a case when there's a circuit split or there's some confusion about the law. And that was not the case, right? And even when you're talking about, when you say judicial activism, right? It was judicial activism because they never needed to hear the case in the first place. And also because usually, like, the court usually has rules about when it overrules something. And the rules are, has the law shifted in such a way that the earlier decision no longer holds? Has there been a fundamental change in facts that forces us to revisit the rule? Or is somehow the rule not workable? Like, it's too hard to apply. And none of them apply to the rule that pre-viability bans are unconstitutional. In fact, I mean, the court has a whole passage about how the rule is unworkable. But the actual rule at issue, which is you can't ban abortion before viability, honestly, that is about as straightforward a rule as you are ever going to get in constitutional law. Because constitutional law is often full of nuance and specific facts and can be difficult. But this rule, no bans before viability, absolutely straightforward. And so none of the general reasons to overrule apply in this case. And so even under its own rules for overruling, it doesn't have a leg to stand on. I mean, they made up new rules, and the new rules were basically, the decision was really bad. The decision was super bad. Like, our own rules are too hard, and this is murder. Like, and so we're going to overrule. So in terms of, this is, again, my supporting, like, this is clearly a case of judicial activism. And I think it is important that people understand that there are certain rules that it's supposed to follow, and it's not even come close in this situation.
Sorry, you missed one step of this, which is from 1980 until 1992, 8 times the Reagan-Bush administrations, in official briefs to the United States Supreme Court, said, please overrule Roe versus Wade. 8 times. I think it may be more, but I think it's 8. 8 times the court either ducked it or said no. Then in Casey, the court met it head on and said, we're asked again. The opinion begins with that. In the first couple, we are asked once again
to overturn Roe versus Wade. And we're not going to do it. Why are we not going to do it? For all the reasons Caroline just beautifully said. And that's the longest discussion of precedent in the history of the United States Supreme Court. The longest discussion of precedent in the history of the United States Supreme Court is in Casey. I'm reasonably sure.
And now we have this new landscape where it's stare decisis for me, but not for thee.
We're reversing the precedent on precedent. I went back and looked at some of this. In the 1990s, there were conservatives who were saying, I was originally against Roe, but now that we have Casey and it's a super precedent, all hell would break loose if Casey gets reversed, because that is basically saying the court doesn't care about stare decisis at all. Well, I have news. The court has never cared about stare decisis. Oh, by the way, I want to be clear about something because I have a lot of friends who might listen. It is my position on America that local, state, and federal judges across the land, before Trump anyway, tried in good faith to follow the law, to follow precedent. My super legal realist critique is only of the Supreme Court. Now, having said that, Trump did put some lower court judges on who are clearly Fox News ideologues and who are, Caroline just went, they're nuts. They're nuts with an agenda. But even they are a minority. They're a minority of the Trump judges, actually. They are a minority of the Trump judges. But the problem is this forum shopping. And somehow these nuts get all the cases in the lower courts. And the Fifth Circuit does not, Caroline, you would agree, the Fifth Circuit doesn't care about precedent, right? At all.
You also asked a question, which we never answered, which I now want to get back to, which is, could we pass a law codifying it at the federal level?
Right.
And I want to point out that the federal government has passed law about abortion in the past, when they banned what they call the so-called partial birth abortion ban. Because, of course, the question would be, does Congress have authority to pass a law having to do with abortion? Because, again, Congress has only the powers that have been specifically given to it in the Constitution. And so you'd have to find something to hang that power on. And I would point out that it has in the past enacted rules regarding abortion. So in theory, because the argument is, and this is probably what Eric may say, or I don't know, it's like, yeah, they're going to pass it, and then the Supreme Court is going to strike it down, saying they don't have authority over this. But again, it's certainly plausible, constitutionally speaking. Politically speaking,
There's no definition of the Commerce Clause that would not include the power to regulate abortions. There just isn't. But I want to be clear. If the Democrats pass a law protecting abortion, it will be struck down by the Supreme Court.
On what basis?
And no,
Congress didn't have authority.
Right. And Justice Thomas laid the groundwork. Justice Thomas, this is maybe one of the smartest things, smart in an evil way, that he's ever done. In that partial birth abortion case, he said, I agree with the majority upholding this only because, or not only, but he phrased it some way, because no one has argued Congress didn't have the constitutional power to do it. So he dropped a seed there. But let's be clear. Let's be clear to your audience. A law in this Supreme Court, a law protecting abortion rights nationally will be struck down. A law forbidding abortion rights nationally will be upheld.
So I just want to understand this, Professor Segall. You're telling me that no one asked in the case of Dobbs, nobody asked for them to decide, there's not in the question presented for them to overturn Roe or Casey. But in this partial birth abortion ban case, because no one made the argument that there wasn't a hook for this, that Congress didn't have the authority for the partial birth abortion ban, Thomas said, this would be a reason for me to not decide this way, but I'm not going to touch it.
Well, what he said was, I might feel differently if somebody.
I might feel differently.
Yeah. You're right.
That
was a great connection you made, and supports everything I've been trying to say in this podcast.
Okay, so the Supreme Court sucks. Like this was basically the theme of our episode from last summer, Professor Segall. I am still invested in this issue of talking about exactly why, in part because of your point you made earlier about how this has been like a 50-year project of messaging from the Federalist Society and all of its donors to get people to believe there's such thing as an activist judge that is essentially leftist in nature, to get people to really embrace concepts like textualism and originalism, which are definitionally regressive, which are the seeds, the bedrock for this opinion, which says we have to look to history. Any metric that's going to have you looking to history is going to be fundamentally regressive and antagonistic to the rights of people who only recently secured rights in this country. Like fundamentally by definition, you have this broader attack on CRT, which is really an attack on teaching any of America's history, which reveals its flaws. I recently did a debate with a conservative that was really insisting on this idea that any critique of America's past is not admitting that America is a great country, which is also apparently like not doing a patriotism, which is something that I'm supposed to feel bad about for some reason. And like this is what they're forcing people into. And I see leftists and liberals succumbing to these arguments, saying, well, I'm not necessarily saying that Tucker Carlson is racist. I'm just saying da 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 da. And the line keeps getting moved back and back and back. People feel like, oh, well, we can't defend teaching of history. I'm gonna, attack the idea that this country has any kind of like baseline failings. I had a debate with Andrew Sullivan where I very strategically made the issue about how unfair America was to non-landowning white men, because I didn't even want to touch the race issue because of how polarizing it is.
Well, I mean,
I'm actually, one of my summer projects is I'm doing a critical race theory analysis of critical race theory bands and how they're really an example of white privilege and white fragility. So
one of the things that has driven me nuts in the last year and a half is, for example, the Heritage Society, which 30 years ago or 25 years ago was bad, but it wasn't awful. And there were people there with some principles, including a very close friend of mine who I basically got 2 clerkships for and who I used to be good friends with, and he was a reasonable 1990s conservative. Heritage is sending out fundraising newsletters all the time about the danger CRT poses to America. I lost my friend over this because I said to him, you're lying about this. You're lying about all of it. It's just racist dog whistling. You're not that kind of person. Why are you doing this? It was sad for me because I lost a friend, but he had no answer other than basically I'm following Donald Trump. It's basically his answer. This is all happening because white people are getting scared. You know this. I mean, better than I do. That's why.
Hashtag not all white people. But it does feel it's a backlash to some victories that liberals on the left have won over the past 20 years or so, where there was some acknowledgement. Not a lot. I got to say, the window was like this narrow. Because I remember like not learning about slavery in my progressive New York high school. And then I guess there's some kids between me and now, like I guess there's some 27-year-olds who got a good education and now they're slamming the door shut behind them.
No, I think that's exactly right. And I also think that the more scared they get, the worse it is going to get. And just one last point about this. I've been thinking a lot about Alito because I blog with Mike Dorff, who was Justice Kennedy's law clerk during the Casey opinion, and his wife, Sherry, who's a law professor at Cornell, tremendous. They're both just tremendous law professors. She hates Alito more than anybody. And I think I've been trying to figure out Alito, and just give me 1 minute here, and then I got to go. I have to go in a minute anyway. When I was at law school at Vanderbilt, Andrew Young came to talk, and he gave a speech that I'll never forget. I was a second-year law student. I was a bleeding heart liberal and all that, and he talked about the Ku Klux Klan, and I idolized Andrew Young. I spent 4 years in Emory in Atlanta in 1970, so. It's just an idol of mine, still is. I think he's an amazing man. And Andrew Young said, as clearly as it could be said, this is not a defense. The Ku Klux Klan is terrible. No one's accusing me of saying, but we have to understand them. Mm-hmm. They're afraid. Mm. They're afraid of a lot of different things. And until you understand their fear, you won't understand them. And to beat them, you have to understand them. I think Alito is afraid. I think Fox News is afraid. I think they're all afraid. And we have to figure out a way to make them less afraid. And I don't know how to do that without force. I don't anymore. Because I don't know what else is going to work.
Without the courts? You said you don't know how to do that?
No, without force.
Without force. Yeah, I'm with you.
Like, the reality is they're used to being in a privileged position. They're used to being on the top of the hierarchy, whether it's a racial hierarchy or religious hierarchy. And this move to equality threatens their status as top dog.
Hey YouTube, thanks for watching. Just a reminder that this is a podcast. You can catch an extra premium episode every Monday for $5 a month at patreon.com/badfaithpodcast. That's patreon.com/badfaithpodcast for $5 a month, an extra episode every week. Additionally, please do consider liking this video, subscribing to this channel. It helps us out. It helps independent media beat the algorithm. We appreciate you. And as always, keep the faith.